My Lord, we have agreed that I, for the second respondent, go first with your Lordship's indulgence. Perhaps maybe your Lordship can give us a direction, bearing in mind the amount of time taken by the petitioner, whether there is any adjustment or correction in the time allocation. Beg your pardon? You gave us 25 minutes. Most likely.
Bearing in mind, we were responding to how many respondents?
I am happy with the 30 minutes, and we shall constrain ourselves to the 30 minutes. My Lord, the application before you is opposed. And my Lord, I wish to begin our opposition to that application by making the argument that the petitioner or the applicant before you this afternoon or this morning is guilty in the most crude fashion of forum shopping. My Lord, I wish to place on record what my humble understanding of forum shopping is, and it is as follows. Where a party knowingly files various matters before courts of law, seeking the same relief about the same issue and hoping against hope for a different outcome. With that in mind, I wish to state the following, my Lord. My Lord, the relief or the prayer, the only prayer that the petitioner has argued before you this afternoon is prayer number 5 in the notice of motion dated the 11th of October this year. And with your Lordship's permission, I will read that prayer to you. It says that upon the hearing, upon inter partes hearing, and pending the hearing and determination of the substantive petition hearing, a conservatory order be issued restraining the Senate as a whole from admitting, processing, dealing, or in any other manner whatsoever considering the motion for the proposed removal of the Deputy President from office by impeachment founded on the notice of motion of the National Assembly dated the 6th of November 2024. And 6th of November is not written as it is ordinarily written, it is abbreviated as 26/9/2024. My Lord, that prayer is identical to prayer number 6 in the notice of motion dated the 2nd of October 2020. It is identical to prayer number 6 in the notice of motion dated the 2nd of October 2024 in petition number 522 of 2024, whose parties are identical to this one. Number 522. My Lord, that prayer, because it is important, I seek your indulgence to read it, reads as follows. That upon inter partes hearing, and pending the hearing and determination of the substantive petition hearing, a conservatory order be issued restraining the Senate as a whole from admitting, processing, debating, or in any other manner, or in any manner whatsoever considering the motion for the proposed removal of the Deputy President from office by impeachment founded on the notice of motion to the National Assembly dated, and again the date is written 26/09/2024. It is the same prayer. My Lord, the issue of Standing Order number 64 and the constitutionality of public participation is an issue in petition 522. Standing Order number 64 of the National Assembly, and whether or not public participation was carried out as required by Article 118 are issues for determination in petition 522, and I will demonstrate that in a moment, my Lord. by reference to the decision of your brother, Mr. Justice Mugambi, in petition 522 delivered on the 11th. My Lord, curiously, my Lord, the notice of motion before you at prayer 7, at prayer 6, contains the following prayer. It states that upon inter partes hearing of this application, I'm reading prayer 6 in the notice of motion dated the 11th of October. And my Lord, that prayer says that upon inter partes hearing of this application or such earlier time as the court may determine, this honorable court be pleased to certify that this matter raises questions of great general public importance, fit for empanelment of a bench of an uneven number of judges for hearing and determination. That is the prayer for empanelment. My Lord, that prayer is prayer number 7 in the notice of motion dated the 2nd of October in petition 522. My Lord, that prayer was argued and determined substantively by your brother, Mr. Justice Mugambi. And that prayer number 6 has not been urged before you today. My Lord, it is important that as you consider the allegation that we have made that the petitioner is guilty of forum shopping, that you, when you retire to consider your decision in this matter, consider the following paragraphs in your brother Mr. Justice Mugambi's ruling delivered in petition 522 on the 11th of this month. My good and learned friend Mr. Macharia has referred to that ruling, and I am referring to the same ruling as he did. My Lord, at paragraph 6, and I will read it quickly, your brother Justice Mugambi records the proceedings as follows: that Mr. Paul Mwite SC for the petitioner in paragraph 6. Mr. Paul Mwite SC for the petitioner in E522 of 2024 submitted that the petition indisputably raises weighty constitutional questions, which he highlighted. This included: 1, the constitutional validity of the standing orders of the National Assembly used to process the impeachment, particularly Standing Order number 64. That is the argument that senior counsel made before you. Your brother goes on to say, which he faulted for providing a short duration of 12 days to complete the entire impeachment process, whose impact it was to impede the adequate and meaningful public participation, a critical constitutional requirement. Again, the petitioner is on record in this matter that is the important issue in this matter. But instead of arguing it as they did in 522 to get certification, now they want conservatory orders. He goes on at paragraph 7. Mr. Mwite further contended that the impeachment process in the National Assembly is a quasi-judicial process and must comply with the provisions of Article 50. My Lord, that again is the argument that was made before you. This is the same issue, the same petition as 522. I wish to jump quickly to paragraph 38, which my good and learned friend Mr. Macharia referred to the end. But the beginning is also important. In paragraph 38, your brother, Mr. Justice Mugambi, states as follows: I listened attentively as the issues in contention in these petitions, as they are being canvassed by the party's advocates. On the issue of constitutionality of the standing orders, the respondent strongly opposed the contention that, that it amounts to a substantial question of law because such issues have been litigated before He then went on to point out that I was keen, however, to pick out the unique challenges that the petitioners have pinpointed in assailing the standing orders that the National Assembly relied on to carry out the impeachment process. Again, it is standing order number 64. It is the same issue that is before you here. In paragraph 39, there was also the question of whether the allegations whether the allegations subject to an impeachment should be circulated to the public with or without the responses from the person being impeached. That was the question that Learned Senior Counsel asked. He impeaches the public participation process for not giving the public an opportunity to consider the Deputy President's responses. It is the same argument that was made before Mr. Justice Mugambi. Paragraph 41, my Lord. Finally, that notwithstanding the voting in terms of the numbers in both the National Assembly and the Senate on the impeachment motion, if the jurisdiction under Article 163 extends to interrogating the materials relied on under Article 145, so as to determine if the threshold to support the allegations was established, either in the National Assembly or the Senate or both. By the time this petition was being filed, it anticipated a challenge to the process in the National Assembly and the Senate. And your brother, Mr. Justice Mugambi, then goes on. I find that given the extensive nature of these proceedings, starting from the National Assembly all the way to the Senate, and due to the massive public interest in the matter, and he then goes on in paragraph 42 to certify this matter as one of great public, he certifies it under Article 163(4) of the Constitution, refers the matter to the Chief Justice. My Lord, I believe I need to say no more to demonstrate that this is the same petition as petition 522. And my Lord, forum shopping arises not from the identification of a judicial officer, but merely the act of filing an identical petition. We all acknowledge that these days when you file, the CTS will allocate it to any judicial officer in that division. My submission is that forum shopping takes place when you file an identical petition seeking the identical relief. My Lord, it has been stated in response to the allegation of forum shopping that a new issue has arisen. And that new issue, my Lord, has been identified as the fact that the National Assembly passed its resolution or considered and passed its motion, and that is what has then given a rise to this cause of action. My Lord, it is not disputed that the National Assembly passed its motion on the 8th of October this year. And again, my Lord, you will clearly see from the ruling of your brother, Mr. Justice Mugambi, that the parties before you today were before him on the 9th. On the 9th of October this year. And my Lord, the fact that Mr. Justice Mugambi's ruling of the 11th of October takes on board the fact that the challenge by the petitioner is both to the proceedings in the Senate and National Assembly, I submit that it was then the petitioner's duty in petition 522, when we were before your brother, Mr. Justice Mugambi, on the 9th, to point out in petition 522 that there were new facts that necessitated his consideration of prayer number 6 in the notice of motion dated the 2nd of October that was before him. That prayer is the same prayer as prayer number 5 that has been urged before you today. That was the right thing to do. My Lord, that having not taken place, and the petitioner having elected to file this petition and the notice of motion that is before you this afternoon, that deed by the petitioner amounts to forum shopping. And I urge your Lordship, therefore, not to proceed and hear and make a determination on the notice of motion that is before you in petition 550 of 2024. My Lord, a possible way out or a remedy has been suggested by my good and learned friend, Mr. Macharia, that the remedy is to stay these proceedings. Or the remedy is to stay 522. My Lord, that request or that motion is not before you. And I submit that, my Lord, the correct thing to do, petition 522 being the first in time, and so as therefore, my Lord, not to be an accessory in forum shopping, what your Lordship should do is direct that this petition be consolidated with petition 522 of 2024, and any relief sought in notice of motion dated the 11th of November, 11th of October, 2024, be canvassed in the consolidated petition 522 of 2024. Any prayers, any relief that is sought, notice of motion dated the 11th of October, 2024, be canvassed within the context of that consolidated petition. To go on and entertain and make a determination as you have been invited to by the petitioners, would, my Lord, would then be facilitative of forum shopping. My Lord, my learned colleagues who will submit after me will submit extensively that the process which the Senate has now embarked on is guided by certain constitutional timelines. And in deference to those constitutional timelines, my Lord, the remedy that the judiciary has come up with is to acknowledge that the High Court's ability to examine, if it has that ability, is postponed until the constitutional process, governed by strict constitutional timelines, set out in Article 145, Subarticle 3, 4, 5, 6, and 7 of the Constitution, is completed by the Senate. My Lord, I am of the view that you should not consider any of the substantive arguments that have been made in support of the notice of motion in respect of public participation or otherwise. But, my Lord, if you are in the unlikely event minded to consider those arguments, I wish to submit that the total population of Kenya is not a factor to be considered when determining whether public participation was effective or not. Article 118 of the Constitution places an obligation on Parliament to facilitate public participation. But the public have no compulsion to participate. There is no corresponding duty in the Constitution that when public participation takes place, then all citizens or a certain category of citizens of Kenyans must participate. And, my Lord, if that argument were to be given any credence, then it would be possible to challenge the election of an elected official by reference to the turnout of voters. You are elected in constituency X where there are 20,000 registered voters. Only 2,000 came out and voted in the election in which you were returned. That is the way the Constitution works. There is no compulsion that everybody takes place. There is no threshold set out in the Constitution for a return on public participation. Again, my Lord, the reference to an opinion poll and to pollsters is again irrelevant in assessing the adequacy or the efficacy of public participation. I submit, my Lord, that in promulgating the Constitution in 2010, the people of Kenya were very deliberate as to the structures and institutions they set up. There are thresholds contained in Article 145, and those thresholds refer to numbers of members of Parliament, both of the National Assembly and of the Senate. And if there are any numbers to be referred to, it is those set out in Article 145. My Lord, there is an allegation that there was a resolution passed at night. And there was a concern at the speed at which the process is taking place. Again, in that submission, there is no statement that the second respondent proceeded or sat irregularly, or that the transition of the resolution from the National Assembly to the Speaker was irregular. My Lord, all of them took place within the prescribed constitutional parameters. This is not impeachable unless it can be established that they took place outside the time prescribed by the Constitution. My Lord, in respect of the order from your brother, Mr. Justice Mwongo, in Kerugoya, and I'm glad to note that my learned colleague, Mr. Ndego Njiru, is now present. When we were before Mr. Justice Mwongo, an attempt to make these submissions that have been made on the part of the petitioner, that there was non-compliance with that order, were made. Mr. Justice Mwongo, and you will see from the pleading, direct that nevertheless, that Kerugoya matter be collidated with matter before the three-judge bench. And my substantive submission is as follows. There is a petition in Kerugoya where Mr. Justice Mwongo gave certain parameters in which public participation must take place. I believe it is petition number 14.
It's in his supplementary affidavit.
It is in the supplementary affidavit filed, RG 19. My Lord, my submission is that this cannot then be the forum in which that order is enforced.
Is there a bench already established?
There is a direction that a bench will be established. I am not sure whether Her Ladyship, the Chief Justice, has established a bench. This matter is not consolidated with the matter where the Kerugoya matter has been consolidated, and it cannot then be a proper exercise of this court's jurisdiction to turn petition number 550 of 2024 into the enforcement proceedings or orders made in petition number 14 of 2024 in Kerugoya. I yield the rest of our available time to Mr. Gumbo and